It took Acting Attorney General Todd Blanche exactly 28 minutes to do what Washington had somehow failed to accomplish for 6 straight years: force Adam Schiff to sit there while the record he had spent years shaping for television was placed back in front of him, document by document, statement by statement, contradiction by contradiction. The setting made the irony almost too precise, because Schiff had once occupied the powerful side of the dais, reading what he later described as parody during one of the most consequential political proceedings in the country, while Blanche had spent his career dealing with evidence under rules that did not allow a prosecutor to substitute theater for proof. Now the positions had reversed. Schiff had the microphone and the practiced posture of an interrogator, but Blanche had something far more dangerous than outrage, slogans, or cable news confidence. He had read the file, not the version summarized on television, not the political interpretation repeated hundreds of times, not the carefully framed talking points that survived because very few viewers ever saw the underlying documents, but the actual material that lawyers were required to examine when the stakes moved from television studios into courtrooms. Schiff was preparing to question the man at the witness table, apparently believing the familiar Washington hierarchy still applied. Yet the hearing was about to expose the difference between controlling the microphone and controlling the evidence. The Senate Judiciary Committee confirmation hearing convened at 10 years that morning inside the Hart Senate office building, every seat filled, network cameras aimed toward the witness table, reporters packed into the gallery, staffers moving quietly behind senators, and the usual Washington audience waiting for the moment when procedure finally turned into confrontation. Todd Blanche sat before them in a dark suit, without a tie, a single folder positioned to his left, and a glass of water to his right, an almost deliberately spare arrangement for a man whose professional life had been built around files considerably heavier than the one sitting beside him. At 52, Blanche carried the resume of a former federal prosecutor from the Southern District of New York, a defense lawyer accustomed to high-profile criminal cases, and a man who had already served 14 months as Deputy Attorney General before becoming Acting Attorney General after Pam Bondi was fired. 6 weeks earlier, he had been nominated to hold the office permanently, which meant this hearing was not ceremonial background noise, but the proceeding that would determine whether the Senate considered him fit to run the Department of Justice. Across from him sat Adam Schiff, a senator for less than 2 years, but a national political figure for far longer, the former chairman of the House Intelligence Committee, a central figure in investigations surrounding Donald Trump, a lead impeachment prosecutor, and a politician whose public identity had become inseparable from the accusations he had spent years advancing. For the first 90 minutes, nothing suggested that the hearing would become anything more than the familiar kind of Washington proceeding that disappears into a C-SPAN archive before dinner. Senators asked about Department of Justice priorities, fentanyl, immigration enforcement, antitrust policy, internal independence, and the ordinary institutional questions that allow both parties to perform their expected roles without forcing either side into truly dangerous territory. Republican senators offered questions that gave Blanche room to discuss policy, Democratic senators pressed him on his relationship with the White House, and Blanche answered with the controlled precision of someone who already understood the machinery of the department he was seeking to lead permanently. There were no explosions, no dramatic interruptions, no obvious viral moments, just the steady rhythm of a confirmation hearing moving through prepared subjects while reporters waited for the exchange they knew would generate headlines. Then the chairman recognized Senator Adam Schiff, and almost immediately the atmosphere changed because Schiff did not approach Blanche as a routine nominee, but as a former attorney for Donald Trump whose professional history could be turned into an accusation about loyalty, independence, and fitness for office. Schiff adjusted the microphone, squared himself toward the witness table, and began laying out the prosecution he had clearly arrived prepared to deliver, reminding Blanche that he had personally represented Donald Trump, sat beside him in a Manhattan courtroom, participated in jury selection, and cross-examined witnesses on Trump's behalf. Each fact was presented separately and deliberately, the familiar method of building an argument piece by piece until the conclusion appears unavoidable, and Schiff's intended conclusion was obvious. A lawyer who had defended Trump could not be trusted to separate the president's personal interests from the interests of the Department of Justice. Schiff then widened the attack, pointing to 16,000 Justice Department employees who had left, investigations involving officials from the Biden administration, the indictment of James Comey over a social media post, and the removal of career prosecutors from cases they had spent years developing. His argument was not subtle, because subtlety would have weakened the television moment. According to Schiff, Blanche had never truly stopped functioning as Trump's defense attorney, and the only thing that had changed was the title printed on the office door. Schiff delivered the accusation with the confidence of someone who had spent years speaking from congressional dais positions, where witnesses were expected to defend themselves while he controlled the sequence, the timing, the framing, and usually the final clip. On the Democratic side, senators nodded, staffers typed rapidly, and somewhere in the press gallery, the exchange was already being reduced into the kind of instant narrative Washington manufactures before the witness has even answered. Schiff had attacked Blanche's independence, integrity, professional record, and qualification to lead the Department of Justice. And by the usual rules of televised politics, that should have been enough to produce the evening headline before the hearing had even reached its next senator. Blanche did not interrupt, did not match Schiff's theatrical rhythm, did not visibly react, and did not attempt to compete for emotional volume, because he had spent too much time in courtrooms to confuse aggression with control. He wrote a single line on the paper in front of him, underlined it, and waited until Schiff had finished, allowing the accusation to arrive completely before deciding where to cut into it. When the silence finally opened, Blanche looked directly at Schiff and said he would address the allegations concerning his independence, integrity, and fitness. But first, since Schiff had chosen to make credibility the standard by which an attorney general should be judged, Blanche wanted to discuss credibility itself. Then he opened the folder, and the hearing stopped being Schiff's examination of Blanche. Blanche told Schiff that in 20 years of courtroom practice, including 8 years as a federal prosecutor and more than a decade as a defense attorney, he had never encountered anyone who had fabricated more evidence across more proceedings on more occasions while facing fewer consequences. Schiff's pen stopped because Blanche was no longer responding to the premise of the questioning. He was attacking the credibility of the man who had introduced that premise in the first place. Blanche moved immediately to the Russia investigation, reminding Schiff that for 3 years he had repeatedly told American audiences that evidence existed connecting the Trump campaign to Russian collusion, including his March 22, 2017 appearance with Chuck Todd on MSNBC, in which Schiff said there was more than circumstantial evidence. Blanche did not present himself as someone relying on pundits, partisan summaries, or recycled commentary, because his central point was brutally simple. He had reviewed the Mueller report, he had studied the Durham report, and, more importantly, as a defense attorney, he had examined the government's underlying evidence with a legal obligation to understand exactly what the prosecution possessed. That was the distinction Blanche wanted the room to absorb, because Washington had spent years arguing about narratives while he was describing the far less glamorous process of reading documents, witness statements, FBI 302s, intelligence assessments, classified material made available for litigation, and the actual evidentiary record lawyers were required to confront. Blanche said the evidence of collusion Schiff had repeatedly described was not hidden in some mysterious corner of the file, waiting to be discovered by a sufficiently committed television audience. According to Blanche, it simply was not there. More damaging still, Blanche argued that Schiff could not plead ignorance because witnesses appearing before Schiff's own committee had already given testimony undermining the public certainty Schiff continued projecting outside those closed proceedings. Schiff attempted to answer by pointing out that the Mueller report established Russian interference in the 2016 election, but Blanche immediately separated the two propositions, because Russian interference and collusion between Russia and the Trump campaign were not interchangeable claims, no matter how often political rhetoric blurred them together. And with that distinction fixed in the record, Blanche moved toward the first question that would define the rest of the confrontation. When Schiff told Chuck Todd that he possessed more than circumstantial evidence of collusion, had he actually said those words yes or no? Schiff hesitated, tried to narrow the language, and said he had spoken about evidence worthy of investigation, but Blanche refused to let the answer drift away from the specific phrase that had been broadcast to millions of Americans. He asked again whether Schiff had used the words more than circumstantial evidence, not whether Schiff now preferred a softer interpretation, not whether the investigation itself was legitimate, not whether Russia had interfered in the election, but whether Schiff had made that exact public claim. Schiff finally acknowledged that he had used the phrase, and Blanche immediately moved on because the purpose was not to argue about what Schiff might have meant 6 years later, but to establish what Schiff had actually said when the political temperature was highest and the public consequences were enormous. The exchange had now assumed the unmistakable rhythm of cross-examination, question, deflection, narrowing, answer, next question, with Blanche treating Schiff not as a senator whose authority should intimidate the witness, but as an attorney whose prior statements could be tested against the documentary record. That shift mattered because Schiff had built much of his public reputation by forcing witnesses into yes or no corners. And now, Blanche was using the same discipline against the man who had spent years mastering it. Blanche turned to James Clapper, President Barack Obama's former Director of National Intelligence, and asked whether Clapper had testified before the House Intelligence Committee by March 2017. Before Schiff made the public statement claiming more than circumstantial evidence of collusion. Schiff initially answered broadly, noting that the committee had conducted numerous interviews during that period, but Blanche again stripped away the protective language and asked specifically whether Clapper had already testified. After a brief look toward counsel, Schiff acknowledged that Clapper had testified early in the investigation, which gave Blanche the foundation he wanted before introducing the substance of what Clapper had actually said under oath. Blanche then read the committee transcript, quoting Clapper's statement that he had never seen direct empirical evidence showing that the Trump campaign, or anyone in it, had been plotting or conspiring with the Russians to interfere in the election. The contrast was devastating in the structure of Blanche's argument. Inside the committee room, under oath, the former Director of National Intelligence said he had not seen direct empirical evidence, while outside that room, Schiff was telling national television audiences that he possessed more than circumstantial evidence. Schiff attempted to place Clapper's statement in a broader context, but Blanche refused to permit the answer to expand until the factual question had been resolved, asking whether the transcript contained those words, yes or no. Schiff eventually conceded that the transcript reflected that language, and Blanche did not celebrate the concession or pause for theatrics because the strength of the sequence came from accumulation, not volume. He moved immediately to Samantha Power, Obama's ambassador to the United Nations, whose testimony before the same committee produced the same basic problem for Schiff's public narrative. Power said she was not in possession of evidence. Blanche asked whether that was what the transcript showed, and after another effort to avoid the binary form of the question, Schiff acknowledged that the transcript reflected the statement. The hearing was now moving away from one disputed television phrase and towards something far harder to dismiss as an isolated misunderstanding, because Blanche was building a line of Obama administration officials whose sworn testimony did not resemble the certainty Schiff had repeatedly projected to the country. Then came Susan Rice, President Obama's national security advisor, another senior official from the same administration, another witness before Schiff's committee, and another transcript that Blanche said failed to produce direct evidence of collusion. Schiff said he would need to review the specific language, an answer that might have sounded cautious in another setting, but now only reinforced Blanche's control of the record because Blanche had the transcript sitting in front of him and offered to read it aloud. Schiff did not ask him to do so, and Blanche treated the refusal as revealing enough, not because silence itself proved every accusation he was making, but because the pattern he was presenting had become impossible to disguise with vague references to context. Clapper had not seen direct empirical evidence. Power said she was not in possession of evidence. Rice likewise had no direct evidence, and all three had testified inside the committee whose chairman later became the public face of certainty about collusion. Blanche's accusation was now explicit. Schiff had heard what his own witnesses said in closed or classified proceedings and then walked into television studios telling Americans something far more definitive. Blanche pressed the institutional point harder, arguing that in a courtroom, a prosecutor who possessed sworn testimony, saying one thing and then represented the opposite to a jury, would face consequences that were immediate, professional, and potentially criminal. He invoked Rule 3.4 of the Model Rules of Professional Conduct to frame the contrast between legal procedure and political performance, emphasizing that attorneys were not permitted to manipulate evidence simply because a preferred narrative was more useful than the underlying testimony. His point was not that Congress operated under identical courtroom rules, but that Schiff had spent years presenting himself with the authority and gravity of a prosecutor while enjoying a political environment where the same evidentiary discipline was far easier to evade. Blanche's sarcasm remained controlled because he did not need to shout. He only needed to keep placing Schiff's public statements beside the testimony generated by Schiff's own committee and allow the contradiction to carry the attack. For a politician whose career had depended heavily on credibility in national security investigations, the danger was not merely that one statement could be challenged, but that Blanche was constructing a pattern in which public certainty repeatedly outran the testimony behind closed doors. Then Blanche changed subjects without changing pace and moved to September 26, 2019, the House Intelligence Committee hearing involving Acting Director of National Intelligence Joseph Maguire and the Trump-Zelensky phone call. He lifted two documents, the actual transcript of the call in one hand and the congressional record of Schiff's opening statement in the other, turning the comparison into something almost brutally simple because the audience did not need a legal theory to understand the difference between words that appeared in a transcript and words that did not. Blanche read the language Schiff had used during the hearing, including the invented phrasing about Trump demanding that Zelensky manufacture dirt on a political opponent, then stated plainly that those words did not appear in the actual transcript. His accusation was direct. Schiff had fabricated dialogue between the President of the United States and a foreign head of state during an impeachment-related proceeding while speaking in a manner that appeared to summarize the call itself. Blanche then reminded the room that Representative Mike Turner had immediately questioned whether Schiff was simply making the exchange up, while Representative Elise Stefanik later contrasted Schiff's improvisation with her decision to quote the transcript directly. Schiff's defense at the time had been that the presentation was intended, at least in part, as parody, and Blanche seized on that word because it captured the gulf between the seriousness of the proceeding and the looseness of what had been presented from the dais. Blanche said that during his 8 years prosecuting cases in the Southern District of New York, no prosecutor could fabricate a phone call transcript, present it as evidence in a proceeding, and then escape responsibility by saying the fabrication was comedic or illustrative. He sharpened the attack by emphasizing the constitutional setting. This was not a campaign rally, a late-night interview, or an opinion segment, but an impeachment hearing dealing with the conduct of a sitting president. The more serious the proceeding, Blanche argued, the less defensible it became to introduce invented dialogue and then retreat into the language of parody once challenged. Schiff had spent years demanding exactness from witnesses, and Blanche was now demanding the same exactness from Schiff's own record. From there, Blanche moved to September 17, 2019, 9 days before the hearing, when Schiff appeared on MSNBC and was asked whether his committee had heard from the whistleblower whose complaint would soon become public. Schiff had said, "We have not spoken directly with the whistleblower. We would like to," a statement Blanche then placed beside 3 independent fact-checking assessments. PolitiFact rated the statement false. The Washington Post fact-checker identified it as Schiff's false claim, and factcheck.org said Schiff had wrongly implied that no contact had occurred. Blanche emphasized that these were not conservative advocacy groups constructed to attack Schiff, but independent fact-checking organizations that had reached the same basic conclusion. Committee staff had already communicated with the whistleblower's representative before the complaint was formally submitted. Schiff's later explanation was that he had meant the committee had not officially interviewed the whistleblower, but Blanche rejected that distinction as a lawyerly attempt to redefine ordinary language after the fact, because the original question concerned whether contact had occurred, and according to the fact-checkers, contact had occurred. Blanche then pulled the strands together. The Russia collusion evidence Schiff publicly claimed was contradicted by testimony from senior Obama officials. The presidential phone call dialogue Schiff presented during an impeachment hearing was not in the transcript and was later defended as parody, and the whistleblower statement was judged false by multiple independent fact-checkers. 3 separate controversies, different dates, different proceedings, different factual records, but the same underlying problem in Blanche's framing. Schiff said something categorical. The documentary record complicated or contradicted it, and the explanation arrived only after the contradiction became public. Blanche called that a pattern, and the word was carefully chosen because a single error could be excused, 2 could be dismissed as coincidence, but a repeated sequence raised the larger question of whether misrepresentation had become a method rather than an accident. With the pattern established, Blanche turned to the next document in the folder, dated June 21, 2023, and the confrontation moved from disputed statements to the formal judgment of the House of Representatives itself. Blanche turned to June 21, 2023, the date the House of Representatives voted 213 to 209 to censure Adam Schiff. And he presented that vote not as a stray political insult, but as the next piece in the pattern he had been constructing throughout the exchange. The resolution accused Schiff of misleading the American public through falsehoods, misrepresentations, and abuses involving sensitive information, and under House procedure, Schiff was required to stand in the well while the censure was formally read. Blanche then moved immediately from the institutional punishment to what happened afterward, producing a fundraising message Schiff had sent to supporters that characterized the censure as a political attack and urged donors to respond financially. According to the Scripps account, Schiff's Senate campaign raised approximately $8.1 million in the quarter following the censure, a number Blanche used to argue that political consequences had not merely failed to damage Schiff, but had become financially useful. The point Blanche was making was larger than one fundraising email. In his framing, controversy generated attention. Attention generated claims of persecution. Claims of persecution generated donations. And the cycle rewarded the very conduct critics said should have carried consequences. Blanche described the sequence with the cold language of a prosecutor dissecting a business model, reducing it to a series of steps rather than treating it as an emotional political dispute. Make the claim, get challenged, call the challenge partisan retaliation, send the fundraising appeal, collect millions, and repeat the process the next time the confrontation produces another headline. The sarcasm was obvious, but it was controlled because Blanche's argument depended less on insult than on the juxtaposition between official rebuke and financial reward. He argued that ordinary Americans who had donated $25 or $50 because they believed Schiff possessed hidden evidence were not participating in an abstract Washington game. They were spending real money based on claims they assumed were grounded in information unavailable to them. In Blanche's presentation, that made the dispute more consequential than an argument between rival politicians, because the public had been asked to trust assertions supposedly supported by classified or investigative material they could not personally inspect. And once Blanche had framed the censure and the fundraising that way, he closed the folder and removed the last physical barrier between himself and the senator he had been questioning. With both hands resting flat on the table, Blanche returned to the accusation that had started the exchange. Schiff's claim that Blanche lacked the independence, integrity, and professional fitness necessary to serve as Attorney General. Blanche said Schiff had spent roughly 12 minutes questioning his credibility, while Blanche had answered using Schiff's own public statements, committee transcripts, fact-checking rulings, and official congressional records rather than relying on personal speculation. He repeated the distinction that had driven the confrontation from the beginning. Schiff had publicly said he possessed evidence of Russian collusion, while witnesses from the Obama administration had given testimony that, in Blanche's interpretation, did not support the certainty of those public statements. He returned again to the Trump-Zelensky hearing and Schiff's improvised rendering of the call, emphasizing that words introduced during the proceeding were not contained in the released transcript, and that Schiff later characterized the presentation as parody. He then returned to the whistleblower controversy and the fact-checking organizations that had challenged Schiff's description of whether contact had occurred before the complaint became public. The structure was deliberate because Blanche was no longer introducing new categories of accusation. He was compressing everything already presented into a closing argument designed to make the audience remember the pattern rather than every individual citation. Russia, the committee testimony, the impeachment hearing parody, the whistleblower statement, the House censure, and the fundraising response were assembled into one continuous credibility challenge. Blanche's central claim was that he had personally occupied the defense table in cases connected to accusations Schiff had publicly amplified, and that his professional role required him to examine evidence at a level cable news discussion never demanded. He said he had read the documents, reviewed witness statements, examined FBI 302s, studied intelligence assessments, and searched for the evidence that had been invoked publicly with such confidence. According to Blanche, after doing that work, he reached a conclusion far more damaging to Schiff than any partisan insult could have been. The evidence Schiff had described in public was not present in the form Schiff had led audiences to expect. Blanche stressed that his assertion did not come from a television commentator, a social media account, or a headline written by someone who had never seen the underlying litigation material. He presented himself as a lawyer who had been legally obligated to locate weaknesses, evidence, contradictions, and every document that could affect the defense of his client, which meant that failing to find important evidence would have been professional negligence rather than political inconvenience. That was why the phrase, "I read the file," carried so much weight inside the source narrative. It represented Blanche's attempt to claim authority not through office, ideology, or television prominence, but through direct exposure to the evidentiary record. He then widened the accusation beyond a single dispute and said that people who fabricate evidence rarely stop after one incident because repeated success without meaningful consequences teaches them that the method works. In his telling, 6 years had passed through impeachment battles, fact-checking controversies, a congressional censure, and dozens of committee transcripts without anyone forcing Schiff to reconcile the public certainty of his claims with the underlying testimony Blanche was now citing. Then, Blanche reached the sentence the script treats as the climax of the hearing, telling Schiff that after years of investigations and public allegations, when finally confronted directly about the evidence, he still could not produce it. The room, as described in the source, went silent for several seconds, with cameras remaining fixed on the exchange, while Blanche allowed the accusation to sit without adding another layer of argument. He ended with the courtroom phrase, "The counselor rests," sat down, aligned the folder carefully with the edge of the table, and folded his hands, refusing to turn the moment into a victory speech. That restraint was important to the scene because the source portrays Blanche's power as coming from discipline rather than spectacle. Schiff had been presented as the politician accustomed to controlling the hearing, while Blanche was presented as the lawyer who believed the record itself should finish the argument. Schiff then asked the chairman for an opportunity to redirect, his voice described as controlled but noticeably thinner than it had been before Blanche began answering him. The chairman turned toward Blanche and asked whether the nominee wished to add anything further, but Blanche declined, saying that he believed the record spoke for itself. A recess followed, and Schiff left the dais surrounded by staff while reporters moved quickly toward the corridor, an exit the script depicts with the uncomfortable precision of a politician attempting to leave without appearing to flee. Reporters also approached Blanche at the witness table and asked for his reaction, but he did not repeat the attack or escalate it outside the formal proceeding. He said that his questions had been based on public records, official transcripts, and independent fact-checking rulings, and that Schiff had chosen not to answer them directly. Blanche then gathered the same folder that had structured the confrontation, left the untouched glass of water behind, and walked out without an additional victory lap, preserving the image the script had built from the beginning. A lawyer who believed the strongest conclusion was the one the audience reached after seeing the record. The first clip to spread widely, according to the source, was not Blanche's closing argument, but the narrower exchange over James Clapper's testimony, particularly the repeated rhythm of Blanche demanding a direct answer while Schiff tried to introduce context. That sequence traveled because viewers immediately recognized the courtroom pattern, even though the setting was a Senate hearing: precise question, attempted qualification, narrower question, forced answer, and immediate transition to the next document. The phrase, "I've read the file," became the central slogan attached to the confrontation, while the side-by-side comparison between Schiff's 2019 rendering of the Trump-Zelensky call and the released transcript circulated independently as another condensed version of the broader argument. Conservative commentators adopted "the counselor rests" as a recurring line in their coverage, while Schiff's office issued a statement attacking Blanche as a partisan figure tied to Donald Trump. Yet, the source emphasizes what the statement did not address directly: the Clapper transcript, Samantha Power's testimony, the disputed whistleblower statement, the phone call parody, and the fundraising figures Blanche had placed into the record. The source then moves beyond the hearing room and into the political aftermath, beginning with a CNN interview in which Jake Tapper confronts Schiff with the same problem Blanche had placed before him. 3 separate fact-checking organizations had challenged Schiff's statement about prior contact with the whistleblower. Tapper asks whether PolitiFact, the Washington Post fact-checker, and factcheck.org were all wrong, and the script portrays Schiff as answering by shifting toward congressional procedure rather than addressing the narrow factual question directly. Tapper presses again. Schiff pivots again, and according to the source, that exchange becomes another viral clip because it reproduces the same dynamic that had already defined the confirmation hearing. The man who had spent years building his reputation by asking difficult questions was now being depicted as unable to answer one without widening the subject, changing the definition, or moving into procedural territory. In the script's framing, the damage was not produced by a new revelation but by repetition, because every subsequent interview appeared to drag Schiff back toward the documents Blanche had already placed on the table. The source describes the Wall Street Journal editorial board using the confrontation to revive arguments it had made years earlier, emphasizing that Blanche was claiming direct knowledge of the evidentiary file rather than merely repeating political commentary. It then depicts the New York Times taking a more cautious approach, observing that Blanche's presentation relied on official transcripts, recorded statements, and published fact-checking rulings, materials whose partisan use did not automatically make the underlying documents partisan. Legal commentators, according to the script, begin debating whether Schiff's improvised rendering of the Trump-Zelensky call could have constituted sanctionable misconduct, an argument the source treats as politically damaging in itself because Schiff had spent so much of his career judging the conduct of others. The confirmation fight consequently changes shape, with Blanche no longer presented merely as Donald Trump's former personal lawyer, but increasingly as a career prosecutor who had turned a hostile interrogation back on the senator challenging him. Two wavering Republican senators then announced their support within 48 hours, while a moderate Democrat asked whether she would defend Schiff's testimony. Record declines to do so. From there, the source escalates dramatically, describing an inquiry into whether Schiff had knowingly misrepresented classified intelligence while serving as chairman of the House Intelligence Committee. According to the script, committee records covering the period from 2017 through 2019 are subpoenaed, two former staffers are deposed under immunity, and their testimony allegedly supports the claim that Schiff had been briefed on the absence of collusion evidence before making some of his public statements. The script then says the Department of Justice, under Blanche's own authority, opens a parallel review focused on whether Schiff had selectively disclosed information favorable to his narrative while withholding exculpatory material. It further claims that investigators examine whether the improvised transcript during the impeachment hearing could amount to obstruction and that a grand jury is convened in Washington. The source presents this as the ultimate reversal of roles. The politician who had helped initiate investigations into others now becoming the subject of an investigation led by the very man he had attempted to portray as unfit for office. The narrative continues with the California State Bar, which the source says opens an inquiry into whether Schiff's conduct violated professional rules governing dishonesty and conduct prejudicial to the administration of justice. The script portrays Democratic leadership as responding with institutional distance rather than a full public defense, highlighting Chuck Schumer's reported statement that he believed in the Ethics Committee process instead of offering a detailed defense of Schiff's underlying record. Schiff's social media activity, normally described as aggressive and constant, is said to go quiet for 9 days, a silence the source deliberately contrasts with the years in which Schiff had rarely avoided public confrontation. 4 months later, according to the script, the Senate Ethics Committee finds that Schiff engaged in conduct undermining confidence in congressional proceedings and issues a formal reprimand. The source then characterizes Schiff as the only modern member of Congress to have received both a House censure and a Senate reprimand, using those two institutional actions as the symbolic culmination of the pattern Blanche had alleged during the hearing. The escalation does not stop there because the source next claims that the California State Bar concludes its review 6 months after the hearing and that Schiff's attorneys negotiate a resolution under which he enters voluntary inactive status rather than face formal disbarment proceedings. It then describes a federal investigation producing a 4-count indictment, including 2 alleged false statement counts connected to Russia collusion claims, 1 obstruction count tied to the withholding of committee transcripts, and 1 count involving the alleged selective use of classified material. According to the script, the trial lasts 4 weeks, and the prosecution relies heavily on 57 committee transcripts, hundreds of television appearances, 3 fact-checking rulings, and testimony from former staffers. The source says the jury returns guilty verdicts on 3 of the 4 counts, and that Schiff receives a 3-year federal prison sentence, $2 million in fines, and a permanent prohibition from holding federal office. These are among the most consequential claims in the supplied script, and within that narrative, they are presented as the legal endpoint of the same credibility dispute that began when Schiff challenged Blanche's fitness at the confirmation table. The source then returns to Blanche and says he is confirmed as Attorney General 6 weeks after the hearing by a vote of 54 to 46, describing the Schiff confrontation as the moment that transformed public perceptions of his nomination. When reporters later ask whether he intended the exchange to become the defining scene of his confirmation, the script gives Blanche a restrained answer. He says Schiff attacked his credibility, he responded with the record, and the record did the rest. Asked whether he feels vindicated, Blanche again refuses the language of personal triumph and describes himself simply as a lawyer who read the file, asked questions, and presented evidence. That restraint is consistent with the image the script has constructed from the first paragraph, because Blanche is repeatedly portrayed as most effective when refusing to perform the emotional victory his opponents expect. The underlying message remains deliberately sharp. If asking a senator to answer questions from official records feels extraordinary, the source argues, that says more about Washington's political culture than it does about the lawyer asking them. The script then narrows from Washington back to an ordinary living room in Scranton, Pennsylvania, introducing a retired steelworker named Frank Kowalski, who had believed Schiff's public claims for 3 years and had repeatedly argued about them with his Trump-supporting son, Danny. Frank watches the confirmation hearing clips, sees the excerpts involving Clapper, Power, and Rice, and begins reconsidering the certainty with which he had defended Schiff during family arguments. He calls his son, admits that he believes he was wrong, and apologizes for calling Danny foolish, while Danny responds that his father had simply believed what he had been told. The emotional point is not subtle because the source uses Frank as a stand-in for millions of viewers who were never able to inspect classified material themselves, and therefore had to decide which public officials deserved their trust. Frank's final conclusion, as written in the script, is that he should have demanded the evidence earlier instead of accepting certainty simply because it came from someone speaking with congressional authority. The closing returns to the same phrases that framed the confrontation from the beginning. I've read the file, the Clapper questioning, the side-by-side phone call transcript, the censure fundraising, and finally, the counselor arrests. The source urges viewers to treat the entire episode as proof that documentary evidence ultimately defeats political performance, repeating its central distinction between a politician controlling a hearing and a lawyer controlling the evidentiary record. It ends by presenting Blanche as a man who arrived expecting to be questioned and left as the person asking the questions, while Schiff is reduced to the figure who had spent years invoking evidence that the script insists he could not finally produce when directly challenged. The final image is deliberately simple: an attorney general sitting behind the same institutional desk occupied by generations before him, reading files, separating assertions from documents, and building cases designed to survive outside the television studio. The source closes where Blanche's argument began. One man had the microphone, the other had the file, and when the performance ended, the record was left to speak for itself.